We've given a lot of attention to questions about the nature of legal causation. We've also asked what legal relevance the causation of actual harm ought to have. In this lecture, we'll ask when people should be held accountable for failures to act. In many cases, individuals have trouble with the law because of their actions: stealing property, punching someone in the jaw, taking pornographic photographs of children, publishing defamatory statements, removing your clothes in public, or selling cocaine. Each of these cases involves a bad act of some kind. But one can also incur legal liability for certain failures to act. Contracts, for example, usually require the parties to perform certain actions on pain of breaching the contract. Parents are legally required to feed their children. Real estate owners must pay property taxes. Conscripted soldiers and jurors must report for duty. Firefighters must fight fires. In each of these cases, omissions can give rise to liability. Legal theorists have paid special attention to a certain class of omissions: failures to assist someone in distress. Police officers are, of course, legally required to help people, as are emergency medical technicians, firefighters, lifeguards, and members of various other professions. Parents, legal guardians, teachers, and child care providers are also required to help the children in their charge. In many jurisdictions, doctors are legally required to provide medical care in emergencies. In most of the English-speaking world, however, the rest of us are not legally obligated to help total strangers, even when their lives are in danger. If you walk along a pond and notice a child drowning, you're not legally required to rescue the child, or even to call for help. Only 3 of the United States impose any such obligation: Rhode Island, Vermont, and Minnesota. So do several nations in continental Europe. Associated normative questions include the following: should the law impose any obligation to assist strangers in distress? Under what conditions, if any, should the obligation apply? What level of liability should be imposed? Should the obligation be civil, criminal, or both? Most English-speaking jurisdictions answer the first question negatively, following the position of an English statesman, Lord Macaulay. Laws requiring bystanders to aid strangers in peril are known as Bad Samaritan laws. Sometimes people call them Good Samaritan laws, but that causes confusion. There are several arguments in support of enacting such laws. Let's consider first what a consequentialist might say. According to consequentialists, a Bad Samaritan law, or BSL, should be enacted if and only if it has better consequences than any alternative law. So we must determine the probable consequences of a BSL and compare them to the probable consequences of the alternative. The first question is whether helping strangers actually produces good consequences. In some cases, it does. In 1982, an office worker named Lenny Skutnik rescued a struggling plane crash survivor by jumping into the icy waters of the Potomac River in Washington, D.C. in January. He saved a woman's life. Surely the freezing water was painful for Mr. Skutnik, who was wearing a short-sleeved shirt. His pain is a bad effect, but the woman's death would have been worse. If a BSL encourages other bystanders to do what Lenny Skutnik did, then to that extent there's a consequentialist case for such laws. In some cases, however, good intentions don't produce good results. Some Samaritans accidentally injure the victims they try to help. Perhaps rescues should be left to professionals. Some rescue attempts fail, leaving no one better off. And some failed rescue attempts also cost the rescuer her own life or limb, which is a worse outcome than if she'd stayed out of it in the first place. A BSL could also have other negative effects. It could encourage individuals to take foolish risks in anticipation of being rescued. It could discourage self-reliance. It could encourage bystanders to snoop on strangers, invading their privacy. It could reduce our quality of life by imposing a burdensome and unwelcome responsibility to keep one another safe. It could also encourage thieves and rapists to pose as people in peril, aiming to lure unsuspecting bystanders into their trap. Another question that a consequentialist should ask is how many bystanders a BSL actually influences. As with many laws, there are individuals who would do what the law requires, even if there were no law. Some bystanders, such as Lenny Skutnik, will aid strangers in peril without any legal incentive to do so. There actually was no BSL in Washington, D.C., where Skutnik made his heroic rescue. On the other hand, there are bystanders who won't do what the law requires, despite the threat of sanctions. Few bystanders will enter a burning building, for example, even if the law requires them to do so, which no actual BSL requires. As usual, consequentialist lawmakers should concentrate on marginal actors, those whose behavior the law might actually affect. In the case of a BSL, these are bystanders who will assist strangers in distress, but only if the law requires it. If there's no bystander whose behavior a BSL would influence for the better, then the BSL is not justified according to consequentialism. But if even one such bystander exists, then we have a preliminary consequentialist case for a BSL. Whether the case is conclusive depends on whether the good effects of the BSL outweigh its bad effects, such as those mentioned earlier. These are difficult questions to answer. Critics of bad Samaritan laws have several other concerns. Rescuing a stranger sometimes requires enduring pain or endangering one's own safety, bodily integrity, or personal resources. Consider the following scenarios. The stranger is drowning in rough water. The stranger is trapped in a burning house that could collapse. The stranger is being attacked by a knife-wielding assailant. The stranger will die unless one of the bystander's kidneys is transplanted into her. The stranger will die unless she receives an expensive medical procedure that she can't afford without a donation from the bystander. The stranger will die of thirst unless she drinks the bystander's only remaining water. You can imagine that more water will not arrive for several days, leaving the bystander very thirsty but still alive if she helps the stranger. The demands made of these bystanders seem excessive. Bystanders are not morally obligated to risk pain, injury, or death for the sake of strangers, nor are they morally obligated to contribute large sums of money. What we have here is an objection from excessive demands. The law should not require anyone to make great sacrifices for the sake of a stranger. Aiding an imperiled stranger may require great sacrifices. Therefore, the law should not require bystanders to aid imperiled strangers. Lord Macaulay accepts something like the excessive demands objection. As a result, he concludes that the law should not punish failures to aid, except for those that are already unlawful for some other reason. A BSL of such limited scope makes no excessive demands. Lawmakers share Macaulay's concern that BSLs will make excessive demands, but Macaulay's solution is not the only one. Consider Rhode Island's BSL. Any person at the scene of an emergency who knows that another person is exposed to or has suffered grave physical harm shall, to the extent that he or she can do so without danger or peril to himself or herself or to others, give reasonable assistance to the exposed person. Any person violating the provisions of this section shall be guilty of a petty misdemeanor and shall be subject to imprisonment for a term not exceeding 6 months or a fine of not more than $500, or both. Rhode Island's statute limits the liability of bystanders in several ways. It applies only to bystanders at the scene of an emergency, so it doesn't require anyone to help imperiled strangers you see on a television news program. It requires a bystander to aid only to the extent that he or she can do so without danger or peril, so it doesn't require anyone to run into a burning building. And it requires only reasonable assistance, which presumably means no one's required to donate a kidney or empty her savings account for the sake of a perfect stranger. Real BSLs include qualifications like these, so as to avoid the excessive demands objection. Let's call such laws minimal BSLs. There are, however, several remaining concerns about even minimal BSLs. First, the terms of these laws are vague. What constitutes an emergency? What constitutes danger or peril or reasonable assistance? Bystanders must know what's expected of them under the rule of law. Defenders of BSLs note that these terms appear in other statutes as well, and that fact-finders such as juries can be trusted to apply these terms to particular facts. A different concern about BSLs finds expression in slippery slope arguments like this one. Lawmakers should not do anything that makes them more likely someday to enact an excessively demanding BSL. If lawmakers enact a minimal BSL, then they become more likely someday to enact an excessively demanding BSL. Therefore, lawmakers should not enact a minimal BSL. The fear is that once lawmakers embrace the notion that bystanders can be legally required to do something for strangers, they'll gradually increase the demands on bystanders, and eventually these demands will become excessive. Defenders of BSLs respond that this fear hasn't actually materialized in jurisdictions with minimal BSLs. Another objection is that there's no intellectually consistent way to support a minimal BSL without supporting a more demanding BSL as well. A consequentialist would require a bystander to make an emergency phone call to save a stranger's life, because that life is worth more than the inconvenience to the bystander. But by the same rationale, it would seem that a bystander should be required to sacrifice an arm for a stranger's life. The stranger's life is worth more than the bystander's arm. Anyone who defends minimal BSLs but not excessively demanding BSLs must articulate a principle, a moral principle that justifies the former but not the latter. There are, in fact, non-consequentialist arguments for BSLs. Consider the following argument. Giving aid to imperiled strangers is morally admirable. Bad Samaritan laws encourage aiding imperiled strangers. Lawmakers should enact laws that encourage morally admirable behavior. Therefore, lawmakers should enact Bad Samaritan laws. This argument's logically valid, so we should examine its premises. The first premise is acceptable. Aiding an imperiled stranger is usually a virtuous action, sometimes even heroic. The second premise is harder to assess. Lawmakers who enact BSLs surely intend to encourage Good Samaritanism, but it's an empirical question whether they succeed. Another question is whether the legal moralist can answer the objection from inconsistency. Sacrificing one's arm for a stranger's life is morally admirable. The legal moralist argument implies that lawmakers should enact BSLs that require such sacrifices, but that looks like an excessively demanding BSL. Perhaps we should modify the argument. Giving reasonable assistance to imperiled strangers, if one can do so without danger to oneself or others, is morally obligatory. Minimal BSLs encourage giving reasonable assistance to imperiled strangers, if one can do so without danger to oneself or others. Lawmakers should enact laws that encourage morally obligatory behavior. Therefore, lawmakers should enact minimal BSLs. This argument doesn't explicitly support excessively demanding BSLs, but neither does it answer the inconsistency objection. On what basis might one accept its first premise without also accepting a more burdensome moral duty to aid? Is it consistent to support minimal BSLs but not excessively demanding BSLs? Answering this question could require us to delve into philosophers' complicated debates about the extent of our moral duties to assist strangers. Many philosophers defend the common sense view that you have some moral duties to help strangers, although these duties are limited. Others argue that your duty to help strangers is limited only by your abilities. They might support excessively demanding BSLs. At the other extreme are those who consider all BSLs, including minimal BSLs, to be morally objectionable, even if it's taken as given that these laws produce more good than harm. They argue as follows. One's not morally responsible for harm that one does not cause. Bad Samaritans who fail to prevent harm don't thereby cause such harm. Therefore, Bad Samaritans aren't morally responsible for harms that they fail to prevent. The law must not punish someone because of something for which he's not morally responsible. Therefore, the law must not punish Bad Samaritans for harms that they fail to prevent. Let's examine premises 1, 2, and 4. The truth or falsity of premise 2 depends on the nature of causation. This is a complex philosophical topic that I addressed in a previous lecture. A Bad Samaritan fails to prevent harm, knowing that harm will likely occur if he doesn't prevent it. On many popular theories of causation, however, the Bad Samaritan does not cause the harm. For one thing, the harm would have occurred even if the Bad Samaritan hadn't existed. And few of us are prepared to accept that one causes all the harms that one could have prevented. Such a theory seems to yield too many causes. Premise 4 sounds plausible. In most cases, when a convict is punished for a harm that's occurred, there's at least a reasonable case to be made that he's morally responsible for it. But there are exceptions to this principle. An accomplice can be punished for a homicide if his partner accidentally kills someone during the course of a crime that they're committing together. The accomplice does not seem to be morally responsible for this death, so the law doesn't seem completely committed to premise number 4. Of course, some argue that premise 4 is true, nevertheless, and that the criminal code is unjust in this respect. Finally, look at premise 1. It's dubious as stated. Consider a parent who fails to obtain readily available medical care for his child. The child suffers complications that proper care would have prevented. On many theories of causation, the parent did not cause the harm, but is nevertheless morally responsible for it. Parents supposedly have special relationship-based moral responsibilities to protect their children. Some proponents of BSLs believe that everyone has some level of moral responsibility to protect everyone else, even without these special relationships. Opponents of BSLs generally disagree. Without settling that dispute, we can conclude that premises 1 and 2 must be revised as